we now have an amended motion to suppress in the Sarah Boone case. And it might get a little messy, but we're going to look at the differences because you might not notice them at first, but I think it's going to give us an idea of the arguments that they are going to use in court for this motion. So when we go down, they've added upon arrival for number 3. So Deputy Rodriguez spoke to the defendant and realized the death had occurred. So she spoke to them on arrival. And then 5 is when we start getting a little interesting. The defendant was ordered to remain on scene while the OCSO conducted their investigation. As ordered, the defendant stayed outside of her apartment for several hours until the investigation was completed. Now, if we look at the original, there was no as ordered, and it was approximately 14 hours during this time. So what they've done is they've gotten more correct with the hours, it sounds like. They've called it an investigation and as ordered. So this is all tied into the Miranda warning stuff, right? Number 6. At some point, the defendant was told is a change, to get into an unmarked vehicle. And what was the original? At some point, the defendant was asked to get into a vehicle. So you can see they're going with she was told to do it. And it was unmarked. It was an unmarked police car. They're making that very clear in this argument. During the investigation, Detective Kopsel asked to see the defendant's phone. The defendant told the detective her phone was on the kitchen counter in her apartment. The detective brought the defendant her phone and instructed the defendant to unlock it. The defendant complied with the demands of the lead investigator. Now, originally, during the investigation, Detective Kopsel asked to see the defendant's phone. The defendant complied and gave her phone to the detective. The defendant was asked to unlock her phone. So, we have complied and gave is now told the detective her phone was on the kitchen counter in her apartment. So they changed it. They added the information about the kitchen counter. The detective then brought the defendant her phone. So the detective brought the phone and then was instructed the defendant. That is not something that happened over here because what they said here, it was asked to unlock. So now it's instructed instead of asked. So basically they're trying to, the way I'm seeing it, is they're trying to change the wording so that this is an order. It's an order. She has to do it. She feels she has to do it, which they're trying to go with a Miranda argument. And I am going to interject here that according to the state, the Miranda argument she got while in this unmarked vehicle was sufficient, but also not required under Florida law for this situation. Now, later that evening, the defendant moved to her ex-husband's home, Brian Boone, for the night. Using her ex-husband's phone, the defendant... Did I skip ahead here? Oh. The defendant called lead detective Chelsea Kopsel on her cell phone. That is not... on her cell phone is right here. This is not a phrase in the previous document. To express her concern that Detective Kopsel was not being truthful about the law enforcement motives as it relates to the defendant, the detective told the defendant she believed this was that before, were trying to trick her and being sneaky about something. So this was an amendment here. They decided to add and being sneaky about something. That's interesting to me. Number 12, this is simply an added statement. It's not a replacement for anything. So the next day, February 25th, 2020, the defendant arrived at the OCSO to retrieve her phone and had questions about this tragic event. So that was the whole statement originally. They've now amended, upon information and belief, a judge had signed a search warrant for the defendant's phone just 9 minutes before she arrived at the sheriff's department. So they're saying that she showed up because she believed and was told the judge had signed a search warrant for her phone. Interesting. Or she found out. Maybe this is like a wording for she found out once she was there. Anyway, this was the added portion. So you can take away what you would like from there. 13, all of the blue parts are simply added. So we'll just read the whole thing. While under the impression that she was retrieving her phone, Detective Lowen had the defendant upstairs into an interrogation room. Detective Lowen wore his firearm on his waist during the entire event. A custodial interrogation ensued immediately after the interrogation. The defendant was formally arrested and charged with the offense. So here's where things get interesting, right? So they're trying to say firearm. So they're trying to use this. I'm assuming that she was like afraid or felt forced or whatever. That's what they're going for. because they can't just make they're making the argument that the Miranda warning wasn't sufficient, but they also have to make the argument that Miranda was required. So they're trying to say right here that she was like compelled, or I'm assuming they're trying to make that argument at least because of the firearm. And they've also added formally here, the word formally, because I think they're going to argue she was under arrest informally before this, or felt she was under arrest informally. And then you scroll down and you'll find out that that is that's it. That's all they changed. How interesting. How interesting. So, what do you think, right? What do you think about their changes? So to me, they're definitely trying to, I mean, they're adding the word sneaky, right? They're adding that he had a firearm on his hip, formally arrested, unmarked vehicle. Like, they're trying to paint a picture to me. They're trying to paint a picture to the judge that Sarah Boone should have been read her rights before this, but also that her rights weren't read properly. So maybe they're trying to make the argument that even if they were read properly, maybe she was mistreated in some way and things should be thrown out. It really just kind of feels like a Hail Mary that was done after they saw how the state responded. Now, what I've noticed here, there's a big difference between the defense here and the state. When the state says this was sufficient, this was allowed, they then list off a bunch of case law. And what you might notice is not here is added case law, which maybe should be here if you're making this argument, because the judge specifically asked in court. I heard it about what is the exact constitutional argument, right? Like they wanted the judge was basically begging the defense, give me the case law for what you're saying. And we're still not getting it. Which makes me wonder if it doesn't exist. Right? Like tell me if I'm wrong. Tell me if I'm wrong, right? Like maybe you have a different opinion here. But I feel like this doesn't help. I don't feel like any of these changes help her. I don't feel it helps. Now, if it what it was, right? Like if it was like told in an unmarked police car, right? If this was here and then it was followed by like case law, like in this case, an unmarked police car was used, maybe, right? But this feels like you know what it feels like? This feels like if Sarah Boone was like adding her own notes. That's what it feels like to me. That's what it feels like to me.